6:35 p.m. As a reminder, if you wish to speak on any item on this agenda, please complete a public comment card and provide it to the planning and zoning staff. Cards must be submitted prior to board discussion of an item. Thank you. Please make sure all cell phones are on silent. Now let's have a moment of silence. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call, Ms. Davidson.
Bruce Guyton,
Here.
William Wiley,
Present.
Margaret Shepherd, here. Frank Fernandez,
Here.
Anthony Brown, James Gallant. Mr. Chair, you have a quorum.
Thank you. Acknowledgement of vacant positions.
Mr. Chair,
Yes.
as you know, City Council within the last couple months passed an ordinance that made changes to the configuration of the board, and today's setup reflects that. We are also pleased to welcome Mr. Bruce Guyton to the board, or back to the board, and I didn't know if he had any comments or if anything was appropriate to say at the time regarding that.
Mr. Guyton?
Okay.
I'm glad to be back.
All right, we are glad to have you. Thank you. Otherwise, no additional comments from staff regarding vacant positions. There are 3 alternate positions that are open at this time. Staff will continue to collect any applications that are submitted and forward those for consideration for the 3 vacant alternate positions. That's all from staff.
Thank you. Meeting minutes. Do you have the date on them? I can't scroll down as fast. Can you put the
Mr.
date on there?
Sorry, Mr. Chair, if I may.
Yes.
Under item 3, additions and deletions to the agenda, staff does have 1 item. For item 8, under workshop items, we would like to provide a space for a brief training or informational component from our legal staff.
Based on the addition, then, do we have a motion to accept the agenda as it stands?
Mr. Chair, could we go through the entire agenda before we, are we making a motion on just a change?
No, the agenda. We already have the agenda in front of us. We just added the addendum.
Okay, I think my concern is that we didn't identify all the items. So even though there are none, I think they still need to be read into the record.
Okay, do you want to approve it after the fact?
It's your call, sir. I'm sorry. Go ahead.
Do you want to approve it after? You want to read it now so we can accept the agenda? How do you want to work this? We've always just reviewed the agenda beforehand, any addendums, and then we vote to approve the agenda presented before us.
I stand corrected.
So who motioned and who co-motioned?
I said second.
And who motioned to accept the agenda?
Renee Burgess. Yes. Bruce Guyton.
Yes.
William Wiley.
Yes.
Margaret Shepherd.
Yes.
Frank Fernandez.
Yes.
Unanimous vote.
Do we have any disclosure by board members, Ms. Davidson?
None, Mr. Chair.
Mr. Chair, I'm not sure, but we don't have the minutes from last week.
No, Ms. Shepherd, they're not yet ready.
Okay,
We'll have them, we hope to have them for the next meeting.
okay.
Well, there won't be any approval this week because we don't have them.
Yeah, that's why I was wondering
Okay.
why I didn't see it in the package. Thank you, Mr. Chair.
Any unfinished business, Ms. Davidson?
None, Mr. Chair.
Can we move on to new business, please?
Item 7A, a resolution of the City Council of the City of Riviera Beach, Palm Beach County, Florida, approving a plat application PA-23-0007 by Point West Riviera Beach, Inc. to replat PA-23-0005 plus minus 2.79 acres of contiguous lots of record into a single parcel of property totaling approximately plus minus 2.79 acres, plus minus 121,532.4 square feet of land area located on the northwest corner of the intersection of Beeline Highway and North Military Trail, identified by PCN 5642-422541-000-0060 and 5642-422541-000-0050, providing for an effective date and for other purposes.
Mr.
Yes, sir.
Chair, for this presentation, I will yield to Principal Planner Jordan McKenzie.
Thank you.
Good evening, Board. Jordan McKenzie, Principal Planner of Staff. For this presentation, this is the racetrack. And I will say there are two things that I need to clear for point of information, point of clarity. One is that it was written to the record, Point West Riviera Beach is the owner. However, it has been confirmed that the owner now is Racetrack. When it was first moved through the processes, it was still Point West, but they have officially taken over as Racetrack. So that is one thing that we want to have corrected in the resolution. And then the other thing is it reads 2.79, but that has also been corrected to 2.80. That is the appropriate number of for the acreage that's being platted at this time. So those are two things that I want to get corrected on the front end. But regarding that, this is the application PA 23007 for the plat for the racetrack on the corner of Beeline and oh goodness, Beeline and North. Thank you, North Military Trail. I'm sorry, I apologize for that. Can't y'all tell I'm nervous? So this is great, but this is the project location for the site. And just some general information regarding the application. This is combining two contiguous lots. It was originally Lot 5 and Lot 6, and now will be one contiguous lot of 2.8 acres of land. For its existing condition, it is vacant, but they are looking to start construction on the project, completing all approvals. And like I said, this is 2.8 acres. It is 122,156 square feet. It is commercial general for the zoning, and the future land use is commercial. This is a copy of the plat and in its entirety. And this has been reviewed by all of staff, including utilities, engineering, as well as our third-party peer reviewer, Ingenuity. They have also reviewed it, and staff does recommend approval because it has met all of our qualifications for for replatting. And that is the conclusion of my presentation. I'm here for any questions if you have any for me.
Ms. Shepherd, do you have any questions?
Just one, you said that this company is now owned by Racetrack.
Yes, it is.
Now, who was it before? I'm not,
Point West Riviera Beach, Inc.
so they sold it to them or transferred it?
Yeah, it was a transfer, it was a sale. And I can have the applicant, I believe the applicant is here. They can speak more to that. But yes, it was transferred over to Racetrack.
Okay, is it the same format as?
Yes,
Very same thing?
Yes, yes,
Just
yes.
the name change?
just the name change.
Okay.
That's correct.
Thank you, Mr. Chair. That's all.
Thank you, ma'am. Mr. Guyton?
Yes, I have one quick question. I see that it has one condition. It says that the final may not be executed until all technical comments are reflected on the final document. Is there a time frame for them to have all of the technical comments reflected?
So to give a little more context to the answer, sir. So the reason that comment or that condition was put in there originally was because there was still an outstanding discrepancy over the signature block for the engineer on the plat. But however, that has since been rectified, and we did not feel it was in the best interest to not move this plat forward because of that discrepancy, but since it's been resolved, that condition has now been retracted and redacted from staff. So to answer your question, there is no timeline because there is no comment. All comments have been addressed at this time.
Okay.
Yes.
Mr. Wiley?
No question.
Ms. Burgess? No comment. Mr. Brown?
Questions?
Mr. Gallen? No. Mr. McKenzie, thank you very much for the corrections you entered initially. Can we now hear from the developers or the interested parties? Please identify yourself with your full name and your relationship to the project, ma'am.
Good evening, board members, staff. Thank you very much for helping us get through this process. My name is Jane Storms with Police Land Surveyors, 5381 Nob Hill Road, Sunrise, Florida. We're the surveyors for the applicant. I'm here to answer any questions you may have.
Shepherd?
None.
Mr. Guyton?
None on the plat. This is dealing strictly with the plat.
This is
correct?
just strictly with the plat.
Yeah, none.
Mr. Wiley?
None.
Ms. Burgess? Mr. Brown?
Just a quick one. In the City of Riviera Beach approval, I see you have approved on the second line. Incorrectly spelled.
I beg your pardon? Can you repeat the question?
Approved,
Approved is misspelled?
yes. In the City of Riviera Beach approval section, second line down.
Officially approved for record. It's been officially approved. I think approved is correct in this case. Has been officially approved.
2 Ps.
Okay, the one I have has 2 Ps. I apologize. We'll make sure it's taken care of. Thank you.
Are there any other questions on this plat? If there's no further questions, do I have a motion to accept plat PA 23007 as presented by the applicant and Mr. McKenzie with the corrections Mr. McKenzie read into the record?
So moved.
Second.
Brent Burgess? Bruce Guyton?
Yes.
William Wiley? Margaret Shepherd?
Yes.
Frank Fernandez?
Yes.
Unanimous vote.
Thank you. Thank you. Let's move on to B, please.
Item 7B, a resolution of the City Council of the City of Riviera Beach, Palm Beach County, Florida, approving a replat, application number PA-23-0010 from Polymix Properties LLC applicant for a request to replat 0.53 acres of land along the west property line of the subject site for the purpose of public right-of-way dedication to the city and creating a legal lot of record. The subject property, property control number 5642422500007060, is located at 7170 Interpace Road, which is on the east side of Interpace Road, south of State Road SR 710 in the city of Riviera Beach, subject property, providing for conditions of approval and providing for an effective date.
Thank you. Mr. McKenzie?
Good evening once again, Mr. Chair and the board. So this is another plat. This is for Polymix at along Interpace Road. So this is the plat resolution. There are no changes for this one, but it is 0.53 acres of dedication, public right of way back to the city. This is the subject site. And so this is just some general information. I would also like to add that Polymix has also already gone through future land use change, rezoning, as well as site plan applications. So this is not a new property. This is not a new development. This is just strictly getting the plat dedication done at this time. And the current zoning is industrial general and future land use is industrial. This is a copy of the plat. Again, this has been peer reviewed by Ingenuity, our third party consultants. Has also been reviewed by the engineering division as well as utilities, and of course planning and zoning. And so at this time, that all of our comments have been addressed and met, and we recommend approval for the plat application.
Mackenzie, this is just basically a replat
Yes.
where Polymex is ceding 0.53 acres of land
Yes.
to the city of Riviera Beach as a right of way. Am I correct?
That is correct.
Thank you.
Yes.
Ms. Shepherd, do you have any questions of Mr. McKenzie?
No questions, sir.
Mr. Guyton?
Just one quick question. When I tried to type in Interpace Road, North 46 Terrace came up, in the Google Maps, and it could be a glitch in Google Maps. So is there some discrepancy in the name, or was it just Google Maps not accurate?
More than likely, so it's just Google Maps. When you put it in the zoning atlas, as well, if you put in Palm Beach, it takes you straight to the address. So,
Okay.
Yeah.
That's all.
Thank you, sir. Mr. Wiley?
No question.
Ms. Burgess? Brown?
No question, Mr. Chair.
Mr. Gallen? I don't believe we need to hear from the property owner for this, ceding the property back to the city. Okay. So if there's no additional questions, do I have a motion to accept the applicant replat PA 230010 as read into the record and explained by Principal Planner McKenzie?
So move.
Second?
Renee Burgess. Bruce Guyton.
Yes.
Margaret Shepherd.
Yes.
William Wiley.
Yes.
Frank Fernandez.
Yes.
Unanimous vote.
Now we're moving on to item 8, workshop items. It has none. Do we have any? Ms. Tanya, correct?
With the, okay.
I see.
It's legal. Is this going to be painless? Is this going to be painless, Ms.
Like 5 slides, not including the cover in the last page.
That's good.
Oh, that's not a great view. It's hard to see the text. Board members, good evening.
Good evening.
I'll try my best to make this painless. As some of you may recall, back in September of 2023, excuse me, I did a workshop that addressed a number of issues: sunshine, public records, hearing procedures, and staff has asked me just to do a very quick refresher. And I think now is opportune since we're proceeding with the newly reconstituted board. And so nothing I'm going to tell you today is really anything new. It's just a refresher and an opportunity to ask more questions.
One quick thing, for the
Yes,
record,
sir.
can you just please, your name?
Yes, sir. For the record, my name is Tanya Early, and I am the attorney for the board. I've met just about every one of you, but for our new board member, it's a pleasure. Thank you.
Thank you.
Okay, so what I want to start with is just the basics of the most frequently received applications that come before the board. I'm going to start with the most general and work my way down to the most specific. So at the most general level is the comprehensive plan. As you all know, the comp plan is kind of like the constitution for the city. It sets forth the goals pursuant to Chapter 163 Florida statutes for the direction that the city wants to move into the future. Chapter 163 requires municipalities to set forth a plan for the orderly and balanced growth within the municipality. So as members of the planning board, you also sit as a local planning agency. So pursuant to that designation, are appointed with the duty of reviewing recommendations to the comprehensive plan. They can be done in the form of a small scale amendment that only addresses a very compact area within the city, or they can be broad and sweeping in the form of periodic amendments through the EAR process, which I know, again, all of you are familiar with. Most frequently, probably what you will see is a request for an amendment to the future land use map. Often that occurs when an applicant wants to attain a particular type of zoning, and the comp plan will tell you what types of zoning is possible within each particular future land use designation. So they may be an owner of property in a particular area that has one future land use designation that doesn't support the zoning that they want. So they may come before you and ask you for an amendment to the future land use map so that they can get the underlying zoning that they would like to see. So when you receive that application, what you're looking at is always comparing it back to the comp plan. That's your touchstone. That is what you're following. Is this requested amendment to the future land use map consistent with the comprehensive plan? Does it go against the stated goals that the city has set for its future growth? At this point, site plans and permitting are too low level, too granular in level, and they're not part of your analysis. Going down to the more, from working my way from general to more specific, the next type of application that you might see, often hand in hand with the comp plan amendment, is going to be a rezoning application. So Chapter 31 of the city's code addresses all of the zoning, it sets forth all of the zoning districts within the city, and it sets forth the allowed uses within each zoning district and the standards for those allowed uses. So examples of allowed uses might be whether or not you can do commercial activities in a particular zoning district. An example of use standards might be, well, what hours can commercial establishments operate? Those things are, again, more specific than your comp plan, which is just future goals for the city. This is now, what can you do within a particular zoning district and how can you do it? So now when you're reviewing an application for rezoning, what you're always doing is, again, comparing it back to the comprehensive plan. Does the request to rezone comply with that? You can't approve a rezoning that doesn't relate back or doesn't to a zoning category that the comp plan does not allow for. So that's the very bare minimum of what you're checking for. In addition to that, staff will review an application for rezoning, and they have certain criteria that they look at, and they will include that in their staff reports to you, which are, of course, as part of the agenda. So your planners are your experts in the field, and they are your go-tos in terms of questions that you may have about the property and about the application and about their recommendations. A typical staff report has 8 categories. I just pulled a recent one and looked at the different things that staff review. Those categories include the following. Number 1, whether the proposed amendment is consistent with the comp plan. Number 2, whether there are changed conditions that would require the amendment. Number 3, whether the proposed amendment conforms to the city code. Number 4, whether the proposed amendment is consistent with existing or proposed land uses. Number 5, whether the proposed amendment would exceed capacity of public facilities. Number 6, any potential adverse impacts on the environment. Number 7, adverse impacts on property value. And number 8, whether the amendment would result in orderly and logical development pattern. So again, those are the things that you're going to find in your staff report, and that's going to be the analysis that's provided by staff. A third, this is not exactly a rezoning, but something that you may see in respect to Chapter 31 is you may get a proposed amendment to the zoning code that amends the text of the code. An example of that might be something as simple as changing the height of fences in a particular zoning district, or it could be as sweeping as creating a new community residence ordinance, which you recently reviewed in the fall. So as part of this process, again, it's not, while not as generalized as the comp plan analysis, it's not as specific as a site plan review. You're not at that granular level just yet. So what you're looking at is, broadly speaking, what is the proposed use of this property? How is the land going to be used? You're not necessarily at the point yet of where dumpsters are going to go, or where what particular structure is going to be on the land, or what the structure is going to look like in terms of design and things like that. Those come at later on. Landscaping, those kinds of things come later on at the site plan review phase. So the next thing is going to be site plan review. So under 3157, the code sets forth the purpose of site plan review, and it's the criteria is there before you. So again, that the proposed development conforms with the comp plan, that the proposed development is not detrimental to neighboring land uses, that it provides for efficient pedestrian and vehicular traffic systems. So this is when you're going to be wanting to look for, well, and I've heard some, if not all of you, comment at different points, well, how are cars going to get in? How are they going to get out? Are you going to create a safety issue? This is near a fast food restaurant. We want to make sure people aren't crossing. No one's going to get hit. That's the time to look at those things. In addition to that, the last bullet point, again, comes from the code. It says whether or not the proposed project will be a viable addition to the community. In that sense, I think the key word is going to be viable, whether or not the actual site plan is feasible, whether it can feasibly be placed on land. It's not really a value judgment of whether or not the actual use of the property is good or not good. It's whether or not can you actually do this on the piece of land where you want to put it, and is it going to create a safety issue? Is it going to create traffic problems? How are you actually going to use that piece of land, and what is the effect on the surrounding areas? So those are some of the things that you look at with site plan review, and just like the rezoning, you're going to get a staff report, and your staff those are your experts in the field. Okay, so the next thing I wanted to cover was, we covered ethics and voting conflicts a little bit last time, and I want to just go over it again quickly. So board members are prohibited pursuant to Chapter 112 Florida statutes from voting on an issue where they have a conflict of interest. So the conflict doesn't necessarily need to be only pertaining to you. It could be pertaining to a spouse, household member, close relative, employer, client, customer, debtor, creditor, or any charities that you might be involved with. Whether or not you have a voting conflict will be considered on a case-by-case basis. And it, in some cases, what we would look at is whether or not you benefit as any more than other people that are similarly situated. For example, if you had something come up in your neighborhood, the laws are not cut and dry, but if something is happening on your neighboring property, you're much more likely to have a conflict than something that's happening 2 blocks away or 3 blocks away. So if you think you have a voting conflict, I would encourage you to please try to reach out to staff so that they can get in touch with me ahead of time, so that we can address it so that we don't have to have any uncomfortable conversations on the record, because I've been there. Not with any of you, but I've been there. So that's the gist of it. So the benefit to you, it needs to be a specific special financial gain that benefits to you over and above the general public or similarly situated people. It can't be remote or too speculative. And again, like I said, I would encourage you to speak with us ahead of time. Okay, so voting conflicts are also referred to in Chapter 286, Florida statutes. That is actually the Sunshine Law. And I know that in the past, I think that maybe with this board, maybe not. I think in the past that board members were thinking that abstaining was okay. I'm going to recommend that we not do that anymore, just because I want to ensure compliance with Chapter 286. So basically what Chapter 286 says is that if you have a conflict or the appearance of a conflict, you can absolutely abstain from voting. There's a form that you fill out, and that form becomes a public record. But you announce your conflict, you fill out the form, and then you don't say anything else about the matter, and you don't need to participate. There's a more general standard that says that you can abstain if the proceedings would be unfair because of your participation, but that is specific to quasi-judicial proceedings. And because this board is a purely advisory board, you don't do quasi-judicial hearings. So really, unless you have an actual conflict or the appearance of a conflict and you fill out that form, I would recommend that you not abstain, just to maintain compliance with this law. Now, if you do have a conflict, we talked a little bit last time about how Chapter 112 Florida statutes allows you to announce your conflict, and then you still get the opportunity to talk about the issue with your fellow board members. Well, Palm Beach County's Code of Ethics is more strict than the state statute. So that code really puts you more on footing with a judge, whereas a judge in litigation, if they have a conflict and they recuse, they don't do anything else with that case. They don't touch it anymore. So the Palm Beach County Code of Ethics it does require that. So if you've got a conflict and you've filled out the form, you can't discuss the issue anymore. You can't participate. You can't sway the vote. You just have to sit, unfortunately, quietly while your board members continue with the process. And that was it. I promised it would be very short. It's just a review. Like I said, we did an extensive training. Staff asked me to do an update, and I'm happy to answer any questions you may have.
Ms. Shepherd?
None.
Mr. Guyton? None. Mr. Wiley?
None.
Ms. Burgess?
Absolutely. I can send that to
To
you.
the board.
Yes, sir. I will forward it to staff, Mr. Sermons, if you could. Thank you. And also I have Form 8B, which is the conflict form, which I will provide to each of you as soon as I leave the dais.
Can we attach it to the document as well?
Sure.
Perfect. That way you'll have everything in writing plus the form.
Sure. And I'll also send links to the Florida Commission on Ethics and the Palm Beach County Commission on Ethics, which they provide ethics opinions and valuable information. I'll send you a copy of the local ethics code so that you have all of that. And again, I think it will probably be efficient to do regular trainings, but once everyone has a baseline, which I know you all do now for sure, to kind of give you any updates in terms of case law or things like that, or anything interesting that's come down from the courts. I want to make sure that you are all apprised of that. Okay?
Brown?
No questions.
Mr. Galvin?
I still have an issue with the comp plan and the way we're still making changes as of right now, knowing that there is an updated comp plan being done. And knowing that we have to still go by the old comp. You know, you're making these changes and not knowing what the future comp plan is going to be. And what if we have a conflict afterwards?
I understand. I understand that. I think I'll let staff weigh in first. I don't want to. I would say we have to live with what we have at the moment, but I'll let them weigh in because they know more about where you are in the process.
Thank you. Yes, from the staff perspective, we do have an obligation to process an application from a landowner that says they want to do X on their property. And right now, the law of the land is our current comprehensive plan. I think to some extent, we may be able to take in consideration changes that we know are forthcoming to certain aspects of the comprehensive plan. But I don't know, I don't believe we could legally not process an application short of some type of moratorium that we could legally not process an application because we are working on an updated comprehensive plan. But when a specific item comes up, and I know not with the comprehensive plan, but with our land development code in situations where we've been working on certain updates, we have made the developer aware of it and said, hey, that this is the change that will likely soon be adopted. Are you open to conforming to what is the direction of the city? We've had those conversations at the table before, and we haven't had significant pushback. But with the comp plan, it is still the law of the land, and I do believe we have to process them under that. But if there's anything else to add from Attorney Early.
Well, I'll say that the legislature they've already moved the law in that direction. That there was a provision, there was a bill that passed last year. There was a provision that allowed. This doesn't fall, the city doesn't fall into this category at all, but they basically took away a loophole that would allow a city to not process a comp plan amendment. So that's the direction that the legislature is headed in, and I would be hesitant to withhold an application for that purpose. But as far as where you are in the EAR process, is there any more information on that, or?
We are in our current comprehensive plan renovation, so to speak. We are in the drafting mode, as you know, from the last update provided from staff, and we have received 4 of the comprehensive plan elements in draft mode. The first step is for staff to give our comments on what they provided, and after they make our comments, to turn it over to this board and the public to get further input to make sure that what's in those elements is reflective of what the city and our boards and our elected officials are looking for. So right now we are in the drafting and review of draft phase of the comprehensive plan, and we will have our formal update at the next planning and zoning board meeting. Yes, we can certainly make sure they are available and responsive to any questions, comments, or concerns of the board, definitely.
Mr. Chair,
Yes, Ms. Shepherd.
who is they that came? Who's Mr. Gallen referring to?
The company that was, you're referring to the company that was hired, correct?
We don't know more.
The young lady,
Huh?
the young lady that came, the young lady.
Oh, okay, you
Yeah.
kept
The comp
saying
plan,
that.
yeah.
Okay,
Mhm.
okay,
She
okay.
explained it every time we get an update.
Yeah, oh, yeah, I know who you're talking about. I just want to make sure that we're talking about the same
Same
person.
thing, right?
Thank you. Mr. Chair, one more question.
Ms. Shepherd, can we just make sure Mr. Gallen is done?
Oh, I'm
before-
sorry.
Mr. Gallen? Okay, sorry. Go ahead, Ms. Shepherd.
Yeah, Mr. took my thought right just that quick. Mr. Gallen always talk about the warehouses. Do we have a comp plan to address these warehouses? Because I'm very disturbed about the one on 8th Street. I had no idea it would be that large, right next to the Azra Estates, that particular building.
Yes.
Sitting right there on 8th Street, I had no idea, Mr. Sherman, that would be that large, with the neighborhood to the right and then across the street.
Yes, with the uses that are allowed in certain districts, that's a piece of feedback that we did bring back to the consulting firm that is working on this. That warehouses and those uses, as well as the types of uses allowed in the downtown corridor of the city, the Broadway corridor, are some of the biggest feedback points that staff received in that. So that was provided and would be reflected in the draft comprehensive plan. But the reason for review, if it's not reflected to the extent that the board and the community want to see, that's the whole purpose of us bringing those drafts to this board, refining it before it goes for any vote before city council. Before we get to the adoption phase, we want to make sure those drafts are reflective of all of the comments that we've received. So we provided that feedback, and when you get a copy of that land use element draft, please let us know if it hits the mark or if we need to do more with it.
One more question, Mr. Chair. Do we have any more land there on 8th Street and Congress? I can't really remember, just near the neighborhoods, because I think that is the biggest problem with those warehouses going up with the dust and the dirt hitting their neighborhood. I can't remember. Do we have any more, or do you have researched that out?
I'm quickly skimming the aerial view of that area of the city south of Dr. Martin Luther King Boulevard. There does seem to be some parcels that are not fully developed, so there's the potential for future development there. Without having done a full review, I can't say for certain, but that area of the city is zoned industrial, and typically industrial buildings use certain types of construction materials to cover as much square footage as possible under air. But there is the possibility for future development in that area, yes.
Do you know how many parcels are open offhand?
Without a study, no, I couldn't say. And after zooming in, I think a lot of the green that I was seeing belongs to Cisco, so maybe there's not as much as I would have thought. But we can, and in fact, I can bring back the analysis that staff did probably a year ago of vacant industrial land in the city, and we provided that GIS map to the board when we previously had that conversation. I can review that again to see if there's any changes and can dust that off, so to speak, and provide it back to you.
Yes, I would really like to know, because before it hits the fan again, I would like to go out and really take a look at it before it gets to this board, because that was quite a controversy with that particular building being there with so many children and seniors in that building. So I would like to know what's open, so I can just give a jump on what is before this board. Thank you, Mr. Chair.
Chair. Yes. Again, just to, I guess to piggyback off what she was stating about Azura Estates and the place that we approved to go there. I was wondering, because I remember when we talked about a barrier that was supposed to separate Azura Estates and the new warehouse, and I thought it was supposed to be a little. Was it 6 foot or was it 12? What was it? Or was it supposed to be landscaping? I was supposed to cover it to where the people who were living on the second floor would not be able to see that warehouse. I thought that was something that we put into the application, to where is that true, correct?
Yes, I believe you're correct. There was an additional landscape buffer along the side of the property bordering Azura Estates. That is correct.
When I drove past, and that's something I noticed passing by, and I was looking at the building. Like I said, it's a nice building, but I was noticing that it didn't seem as high as what was stated. And it seemed like that would be an issue. So is that something that we have to wait 4 or 5 years, I guess, for the landscape to be able to grow in? Because I thought they were going to bring in the trees or whatever that were going to be already that size so that the people in the Missouri states wouldn't have to do that from the beginning.
I'll need to double check the development plan and conditions on it. The land development code does have minimum requirements, minimum measurements for landscaping when it's installed. And when we do inspections before they can occupy the space, they do have to make sure staff makes sure that landscaping to those minimum specifications are installed on site, or they'll fail and have to replace the plants. So I'll double check as to what was prescribed for that one. And many times we may say the width of the buffer has to be expanded. So it may have said instead of a 10-foot separation buffer, this one is going to provide 20 along that portion. We typically don't say a minimum of 6-foot tall trees to be installed in an area, but I will review to make sure that the language that was put into that site plan is what's reflected. We'll double check that.
All right, thank you. And as of now, has anyone from there made any complaints or anything yet, to your knowledge?
No, not to my knowledge. We haven't received any complaints or issues.
Good. Thank you.
Actually, there was a complaint. I won't say the name, but as far as truck traffic coming out of that property, going, not following the roadway and making improper maneuvers out of it. So there was a complaint regarding that, but nothing as far as the neighborhood next to it, to my knowledge so far.
Thank you.
Yes, Ms. Burgess.
I do have something I would like to clarify with the council. During the presentation, you mentioned there's certain things as a board that we could do. So I know a lot of the times in the past, we have set conditions to applicants outside of
Well, there are two levels I can answer that question at. Number one, certainly an applicant can do something voluntarily. And the board can make recommendations. I've seen the board ask for an update to determine what happened in terms of the impact, the economic impact of any given project. But I'm always conservative, and I would recommend conservative in the sense of wanting to keep everyone on the correct side of, an issue in terms of the law. And I would always recommend that you try to make sure that whatever is asked for has a nexus to the application that's before you, and that it's not disproportionate to the application. And that those are the two criteria for what's called an exaction under the law. So, for example, if an applicant comes in and they say, I want to rezone my property, and I want, I want to do, that's maybe not a good example. They may come in for some sort of site plan approval, right? You could say, do X, Y, and Z to decrease traffic, or maybe we would recommend in order to reduce impacts in easement or something. I don't even know, something like that that's directly related to what they're applying for. But if you say something that's completely, unrelated or completely disproportionate, like that's a disproportionate financial impact based on what they're asking for, the law does not look favorably on that. Does that make sense? It kind of depends on the issue, and it depends on how closely it is related to the application that's before you. Right. Well, I would certainly, if I saw something, I haven't seen anything completely, just off base that I think would qualify as an illegal exaction. But if I did, I would say, maybe you might want to think about not doing that. The good thing is that this is an advisory board and that you have the ability to make recommendations, but at the end of the day, the final backstop is going to be city council. And some of the things that come before you that may not be quasi-judicial when they're before you, they are quasi-judicial when they get up to council. And at that point, whatever they're doing has to be based on competent, substantial evidence in order to withstand a court challenge. So you have a little bit more leeway, and if there are errors made, they can be corrected at the city council level. But if I see something that's just completely going off base, I will let you all know. Yes, ma'am.
I got to piggyback off Mr. Burgess. As you well know, with the jobs, I and others on the board have always asked every developer equally across the board, are you amenable to hiring local vendors and Riviera Beach residents? I didn't say if we pass this, you have to. So we're very clear on that, and we've asked everyone. So we should be okay on the legal end of it, because we haven't forced anyone to do anything in order to pass anything before this board.
Like I said, I have not seen anything that I think would rise to the level of an illegal exaction.
Now, as far as piggybacking on Ms. Shepherd and Mr. Wiley's, I have, whenever there was a buffer between industrial and residential, I've always asked the applicant if they were amenable as far as the amendment, instead of planting a 3-foot tree that will grow in 30 years.
Right.
If they've been amenable to it. And they've agreed, everyone that's been up there has agreed to planting beyond the minimum standards. And I believe, Mr. Thompson, I've been very clear on that on the record, and they've agreed to it. So if there's an issue where they planted a 3-foot, 4-foot sampling in the Azores, and you go back on the record and they agreed to something else, which is what we told them, I wouldn't be too happy with that. Because I know for a fact that the second floor was mentioned. Everyone who stood up there agreed that they will go beyond, and they've all stated on the record, yes, we've gone beyond the minimum standards. Do you recall those conversations we've had? If you don't recall, it's on the record.
Yes, we'll go back and review that. Yes.
Okay, and the last items is when you forward the items tonight plus the Form 8A, is there a way that we can include a hyperlink for Title 31 and the current comp plan, so that when they get this, the board will have access to both? If you can. I mean, it shouldn't, that way it's just easier. So when you put Title 31, they can read it. When you put the comp plan, they can read what the current plan, comp plan is. And again, going back to the comp plan, I know you discussed, and we've discussed this in the past. You've gone to the developers and the applicants and said, we are working on this. Would you be amenable as part of the application process as an addendum? And you've included, your staff has included extra amendments to that particular application, and they've agreed to it. So even though it's not in the comp plan, we know it's coming. I haven't seen any developer yet say no to any of your staff recommendations.
That's correct. And we add conditions to usually the site plan as discussed on this floor. Staff typically brings some standard conditions beforehand and based on review. But if anything else is discussed by this board, or your recommendation includes that condition, we carry it over into the staff report and bring it forth to City Council.
Thank you. I have nothing else.
Mr. Chair,
Ms. Shepherd.
I think I reached out to you, Mr. Sherman, about is it the go-kart place? Am I saying it right?
Yes.
Now, they just told me that they're working there and that they're using West Palm Beach. Yeah, instead of saying Riviera Beach, like the Rapids once did, they're saying West Palm Beach. I'm just waiting till it really open and that individual work so I can actually see what their check is looking like or how is it written out, because I'm sure they're gonna have advertisement. But I think we should start looking at that because they should say, and they stand here and they say, we will use Riviera Beach. But like the Rapids for many, many years used, I think West Palm Beach or Palm Beach Gardens. I can't quite remember how they mark it out. And finally, the city said enough is enough, and they changed over immediately to Riviera Beach. But that's just something you all look at. You all have the computers, and you all can kind of pick it up. But they're not saying Riviera Beach on it.
Actually, that's another thing we had asked them to do. If you recall, with the signs and everything and the advertisement, and they agreed that they will, because we have an ordinance, they will make sure it's Riviera Beach and they will remove West Palm Beach. So if they haven't done so, can we send them a polite reminder?
Yes, we can do that. I haven't seen any marketing materials come from the company yet, only what Ms. Shepherd brought to our attention, but we will be monitoring that because it does state in our land development code to that effect, and we also include that condition on site plans as kind of a belt and suspenders to make sure that they're aware that in terms of marketing and advertising the business, that they need to utilize the city's name and not others.
And we've reinforced that through our meetings as well.
Correct.
And they've agreed to it. It's on the record. So let it respond back when you get a chance to us on what you've researched.
Mr. Chair, let me ask one more question. Is there a fine for that? I think at one time over on the island, they were charging, I think, $500 a day.
Yes, the ordinance does include a fine associated with violating that provision of the code.
Okay, I just want to go on record that if they're violating, because they stood right here and said they would mark it out as Riviera Beach. And, people are talking about it being open soon. And if they're doing that, I think that we should get our kudos that we're bringing these particular things into the city, and it should be marked Riviera Beach.
Agreed.
Thank you, Mr. Chair.
Thank you, Ms. Shepherd. Ms. Burgess.
I believe K1 Speedway is what you're referring
Yes.
to.
Yes.
Shepherd?
Yes.
Yes, right off of 95.
They have a couple out in Florida. This is Riviera Beach. Okay.
Oh, it is saying Riviera Beach.
That's on the website.
Okay, well, I just want to wait and see them open, and the person that told me, I want to make sure I see a check or something before you start making these allegations, but they did mention it to me. They said they were hired there and they were astonished that it was saying West Palm Beach. So let's wait and see how it rolls
Thank you.
with them. Thank you, Mr. Chair.
Ms. Early, thank you so much.
My pleasure. Thank you.
Ms. Davis, do we have any public comments?
No, Mr. Chair.
Staff updates?
Oh, Mr. Chair.
Any correspondence?
None, Mr. Chair.
Again, I'd like to welcome Mr. Bruce Guyton to the board. Welcome to the team. And I have here upcoming Planning and Zoning Board meeting, March 14th, 2024.
That's correct.
Okay, if there's nothing else, do I have a motion to adjourn
I
at
got one more.
7:34 p.m.?
Oh, one more comment.
So moved.
Oh, one more comment.
For planning and zoning comments, I wanted to, I guess, clarify something. We spoke earlier, and I don't know whether I missed the meeting or not, but when we spoke about the new format that we have here with the planning and zoning board members, and we stated of how we were going to be placed, and then I guess more specifically about how things will be handled with the planning and zoning board. And I thought that was supposed to go to the board, and then with the suggestion come back to us with what or what they were going to, I guess what they said or what their recommendation was, and then it was going to go back then at that point. It seems as if it went to the board and then it never came back and we just implemented that. Or did I miss that meeting?
Are you referring to the ordinance that reconfigured the
Right,
board
with the
seating?
reconfiguration and then with, I guess the voting rights. Remember, we talked about how members are going to be brought onto the board and then how, I guess if it was, Area 3 or Area 4 or whatever, that was going to be tied to a certain board member. And I thought we was trying to come up with that format. And then it came from us. We made sort of a suggestion. It got sent to the board, and then I thought it was supposed to come back to us first. And then it was gonna go back to the board with certain recommendations. But it just seemed like it just got implemented without the planning and zoning board.
From the staff perspective of when this came, I think 2 or 3 times when we had the conversation about that restructuring, the staff understanding was that we would compile all of the comments and feedback of the board and what was stated. And that is what we included in the staff report and recommendations for ordinance amendments that was sent to City Council for a decision and determination. And there were some additional edits, if I'm not mistaken, made by City Council when it took place. But the process for ordinance changes for the land development code is that it goes to the planning and zoning board, then City Council for a decision, not that it goes back to P&Z before adoption.
Right, but I thought that was something that we stated though before we sent it to we sent it to the board, that it was going to come back to us with other suggestions or whatever like that, and then it was going to go back to them for final approval. That was my interpretation of the conversation that we had.
Mm-hmm. I don't believe that was the staff understanding that it was to go back to P&Z after going to City Council. So I think we may have had a misunderstanding as it relates to that. We did follow the typical path of an ordinance in that regard. But if additional conversations about what the ordinance is, we can certainly put it on the agenda to discuss more in a certain format if that's desired.
Well, it's in play now, so I guess it's not a concern. I just wanted to know, just for going forward in the future, that was something that was, I guess if I heard wrong, it was something that was stated that I was expecting for that to come back to kind of find out, because the way the board members were getting voted on before, I know we made a suggestion about certain members for the board to vote for a certain number, and whoever had the highest numbers was the most recommended person for that position, then that was the person that was implemented to come onto the board, rather than having a specific board member just put in a person for that position. And I thought that's something that we were talking about and discussing on whether that was going to be implemented or not, and then it was going to go to the board to make that decision, and then come up with suggestions, and then come back to the planning and zoning board for us to kind of get a feel of what that was going to be, since it's our board. And then it was going back to them for final approval.
I do recall bringing up the appointment process with City Council when it was discussed in the suggestions of this board. We did move forward what they deemed most desirable when they passed their vote, and based on the conversations that were had in front of City Council. So the process as prescribed by the code does have a appointee and an alternate for each council district, and an at-large appointee and an at-large alternate. So the nomination that's brought to City Council is based on the person sitting for that district. Before that person makes a nomination, I think it is possible that we send those applicants to the P&Z board, so you all can be aware of any applicants, and I can talk it over with legal. It probably makes sense that since you make a recommendation to the board on things related to land development, that a recommendation regarding appointees could be within that purview. I will talk that over with legal and those appropriate to determine if that's something that we can still implement within the confines of what was passed by City Council.
All right, one more question. even with that being implemented, we have, I guess, a format for us. Let's say, for example, would it be a certain time frame for that? Let's say, for example, another member comes in, a new council person comes in. At that time, does that planning and zoning board person change? As that new person comes in, does that person now vote and bring in their person to be able to represent them, or that person just stays there until that person is no longer there, and then at that time they vote for another person to come into that position?
Until that term expires, that
To the term.
person seated would remain in that
Okay,
position.
so that's what I'm getting at. So if that person's term is up and that person is in that position for planning and zoning, the person who's in council is allowed to change that person.
That's correct.
Wow.
Mr. Chair, I understand what Mr. Wiley is saying. I think when I came back on board, first with Mr. Guyton, because I was in District 1, then I moved to District 2. Was it District 3. And Cedric Thomas immediately put me on the board. And I think it was 2 people there already. So he allowed me to bump that person out of that particular position. So my thing, I think, is the will of the board, how they operate. But they were very upset. But he specifically did not want me to be an alternate. I'm talking about Cedric now. I think there's 2 people there already in District 3. I bumped them and I went right into District 3. So this is the way I think they operate. I think they want their person in there. They will put their person in there. And that's a part of being council. This is what they want to do. They can do it because they do have the last say so. Thank you, Mr. Chairman.
If there's no other questions, oh, go ahead, Ms. Burgess.
To Mr. Wiley's point, if we could just have a copy of the final version of what this
Email to us, yes.
Yes, ma'am. Absolutely.
Okay, try one more time. It's 7:42 PM. Do I have a motion to adjourn?
So move.
second.
All agreed.